Right now, there is a lot of fear and confusion spreading online about a so-called massive immigration reform that people claim has already taken effect. You may have seen videos or posts warning that millions of immigrants have suddenly lost their protections, that green card holders are being deported for minor issues, or that immigration law has changed overnight. Understandably, these messages are causing panic for families who have built their lives in the United States. Here's the important fact you need to know from the very beginning. Those claims are not accurate. While there are real immigration bills and policy proposals being discussed in Congress, nothing has suddenly become law in the way social media is suggesting. Immigration law does not change overnight, and when changes do happen, they follow a clear legal process. In this video, Legal Lens USA is going to slow things down and walk you through the facts step by step. We'll explain what is actually happening, what is still only being proposed, and what the current law really says without exaggeration or fear-based language. Our goal is simple: to replace panic with clarity and help you make informed decisions about your future. At Legal Lens USA, we focus on accurate, reliable immigration information because your future deserves facts, not rumors. Before we go any further, it's important to be clear about what this video will actually cover and, just as importantly, what it will not do. This is not a fear-based warning, and it's not speculation. This is a factual breakdown designed to help you understand a complex topic in a calm, organized way. First, we'll explain what H.R. 875 actually is, what the bill is called, why it was introduced, and what problem lawmakers say it is trying to address. Next, we'll walk through where this bill currently stands in the lawmaking process, so you understand the difference between a proposal, a vote in one chamber of Congress, and an actual enforceable law. Then we'll discuss what would change if H.R. 875 were to become law, focusing specifically on how DUI-related offenses could affect immigration status under the proposal. After that, we'll clearly explain what the current immigration law says right now about DU, because this is where a lot of misinformation is spreading online. Finally, we'll close with practical, responsible steps you can take today, not out of panic, but out of preparation. These are steps designed to help green card holders, visa holders, and families understand their situation and reduce risk. The goal is clarity, not fear, so you can move forward informed and prepared. H.R. 875 is a proposed piece of federal legislation introduced in early 2025. Its full bill name clearly outlines its purpose to amend existing immigration-related provisions under U.S. federal law. Like all bills introduced in Congress, H.R. 875 began as a proposal, not a rule, and its impact depends entirely on whether it completes every step of the legislative process. On June 26, 2025, H.R. 875 passed the U.S. Senate House of Representatives with a recorded vote, signaling that a majority of House members supported moving the bill forward. However, passing the House is only one stage. After House approval, a bill must be reviewed by the Senate, where it's typically referred to a specialized committee. In this case, H.R. 875 is currently under review by the Senate Judiciary Committee, which handles immigration and constitutional matters. Importantly, the Senate has not voted on H.R. 875. Because of that, the bill has not been sent to the President, and it has not been signed into law. To become law, a bill must pass both the House and the Senate in identical form and then be signed by the President until all of those steps are completed. No legal changes occur. Clear fact. H.R. 875 is not law at this time, and it does not currently change immigration rules or legal status for anyone. If H.R. 875 were enacted into law, it would introduce major changes to how DUI-related offenses are treated under U.S. immigration law. Most notably, the bill would create new grounds of inadmissibility based on DUI offenses. This means certain individuals could be denied entry into the United States or refused visas solely because of a DUI, even if the offense is classified as a misdemeanor under state law. The bill would also establish new grounds of deportability, allowing immigration authorities to initiate removal proceedings against non-citizens with DUI histories. These provisions would apply to both misdemeanors and felonies, and not only to formal convictions, but also to cases where a person admits to the conduct during an immigration or border interview. The impact would extend across multiple categories, including visa applicants, adjustment of status applicants, and green card holders who travel abroad and seek re-entry. Under H.R. 875, even a first-time DUI could potentially trigger removal proceedings depending on how the law is enforced. Another serious concern is the lack of clear waivers or judicial discretion, which limits an immigration judge's ability to consider rehabilitation or individual circumstances. The bill also raises questions about retroactive application, meaning past EUIS could be used against individuals years later. While the proposal has drawn White House interest and bipartisan attention, many immigration attorneys have expressed concern about its breadth, fairness, and long-term consequences for otherwise law-abiding immigrants. Under current U.S. immigration law, a simple DUI is generally not an automatic ground for deportation. In most cases, a single alcohol-related DUI without additional aggravating factors does not by itself make a non-citizen deportable or inadmissible. This distinction is important because immigration law focuses not only on the offense itself, but on the surrounding circumstances. However, DUIs can become serious immigration problems in specific situations. Multiple DUI convictions may raise red flags about public safety or alcohol dependency. Drug-related DUI including driving under the influence of controlled substances or prescription misuse, are treated far more harshly and can trigger inadmissibility. DUIs involving injury, property damage, or other aggravating factors such as excessive speed can also increase immigration risk. Additional issues like driving without a valid license or having a child in the vehicle may further complicate a case. DUIs can also affect naturalization applications where applicants must show good moral character during the required statutory period. For undocumented immigrants, a DUI arrest often leads to ICE contact through local law enforcement. Green, cardholders traveling internationally may face extra scrutiny at re-entry even if the DUI occurred years earlier. The key point remains current law still applies today until any new legislation is enacted. Existing immigration rules, not proposed bills, govern how DUIs are evaluated. H.R. 875 has generated significant concern among immigration professionals because of its extremely broad scope and the way it reclassifies DUI-related conduct under immigration law. Traditionally, DUIs have been evaluated on a case-by-case basis with careful attention to intent, harm, and surrounding circumstances. H.R. 875 would move away from that approach by treating DUI offenses similarly to far more serious crimes, regardless of whether anyone was injured or whether the offense was a first-time misdemeanor. One of the most troubling aspects of the proposal is that it would remove discretion from immigration judges. Judges would have little to no ability to weigh rehabilitation, time passed, family ties, or community contributions. This rigid framework raises concerns about fairness and due process. The bill also introduces a retroactive risk, meaning past DUI incidents, even those resolved years ago, could suddenly carry immigration consequences. Additionally, H.R. 875 allows admissions without formal convictions to be used, creating the possibility that statements made during routine interviews could trigger serious penalties. Many attorneys also question proportionality. U.S. citizens typically face fines, license suspension, or probation for DUI, while non-citizens could face permanent separation from their lives in the U.S. This imbalance heightens the risk of family separation affecting U.S. citizen, spouses, and children, and is a central reason H.R. 875 has sparked widespread concern. The most important message right now is, do not panic. H.R. 875 is not law, and no immigration rules have changed at this time. Your legal rights, immigration status, and current protections remain governed by existing law. Staying calm and informed is far more productive than reacting to headlines or social media speculation. That said, this is a good moment to be proactive. If you have any criminal history, including a past DUI, it is wise to consult an experienced immigration attorney who can review your record and explain how current law applies to your specific situation. For those who are eligible for naturalization, applying for U.S. citizenship may reduce future immigration risk, but this decision should be made carefully with legal guidance. If you are a green card holder planning international travel, seek legal advice before leaving the U.S., especially if you have any arrests or convictions on your record. Re-entry is often where issues arise. Individuals currently facing DUI charges should ensure their criminal defense attorney coordinates with an immigration attorney before accepting any plea or resolution, as small details can have major immigration consequences. Finally, the simplest and most effective step is also the most practical. Avoid driving under the influence. Responsible choices protect not only your safety, but also your immigration future. To stay accurately informed about H.R. 875, it's important to rely on official and reputable sources, not social media rumors or viral headlines. The most reliable place to track the bill is Congress.gov, the official website of the U.S. Congress. There you can view the bill's text, current status, committee activity, and any recorded votes in real time. In addition, following organizations like the American Immigration Lawyers Association (AYA) can provide valuable professional insight. ILA and well-established immigration law firms regularly publish updates, legal analysis, and practical guidance that explain not just what is happening, but what it actually means for immigrants. If H.R. 875 moves forward, there will be public hearings, committee debates, and extended discussion in the Senate. These steps take time and are highly visible. Immigration legislation does not advance quietly or without notice, especially when it has wide-ranging effects. This is important reassurance. Major legislative changes do not happen overnight or in secret. There is typically ample warning before any new law takes effect, allowing individuals, attorneys, and advocacy groups time to respond and prepare. Staying informed through credible sources ensures you receive accurate information without unnecessary fear or confusion. It's important to understand H.R. 875 within the broader context of U.S. immigration law. Immigration policy is constantly evolving with new bills, introduced during nearly every session of Congress. However, a critical fact is that many proposed bills never become law even after receiving significant attention or passing one chamber of Congress. While House passage is meaningful and shows political momentum, it is not final. The Senate process is often slower, more deliberative, and can significantly change or halt a bill altogether. This is why relying on incomplete information or early headlines can create unnecessary fear. In an environment where laws and policies may shift, the quality of information matters. Accurate fact-based guidance from official sources and qualified legal professionals is far more valuable than speculation. Misinformation can lead people to make rushed decisions that harm their long-term interests. Another key takeaway is that secure immigration status reduces risk. Permanent residence and eventually U.S. citizenship, if eligible, provides greater protection during periods of legal uncertainty. Rather than reacting with panic, individuals should focus on long-term planning, compliance with current law, and informed decision-making. Staying prepared, not alarmed, is the most effective way to navigate changes in the immigration landscape. When navigating immigration questions, especially during periods of legal uncertainty, it's essential to rely on trusted official resources. The USCIS website remains the primary source for accurate information on immigration benefits, forms, processing updates, and policy guidance. USCIS also offers online tools and case trackers that help individuals understand where they stand under current law. For case-specific questions, the USCIS Contact Center can provide general procedural information and clarify notices or requests, though it does not replace legal advice. When legal guidance is needed, it's best to seek help from a licensed immigration attorney. The American Immigration Lawyers Association, AYA, maintains a public directory that allows individuals to find qualified attorneys by location and area of practice. Those who cannot afford private counsel may be eligible for assistance through nonprofit organizations and low-cost legal aid providers, many of which specialize in immigration law and serve vulnerable communities. A critical warning: avoid notarios, consultants, or unauthorized practitioners who promise quick fixes or guaranteed results. These individuals are not legally permitted to provide immigration advice and often cause serious, irreversible harm. Choosing verified, reputable resources protects both your case and your future. Here's a clear summary of the most important points regarding H.R. 875. H.R. 875 is a proposed bill, not law. Despite headlines, it has no legal effect until it completes the full legislative process. Pass the House pending Senate review. House approval is an important step, but the bill must still pass the Senate and be signed by the President to become law. Would significantly change DUI consequences if enacted. H.R. 875 could make even minor DUI offenses a serious immigration risk, affecting admissibility, deportability, and international travel for non-citizens. Current law still applies. Under existing immigration law, DWS generally triggers serious consequences only when aggravating factors like multiple offenses, drug involvement, or injuries are present. Legal advice is essential for individual cases because every case is unique. Consulting an experienced immigration attorney can help protect your status and guide decisions regarding criminal or travel matters. Citizenship offers the strongest protection for those eligible. Naturalization can reduce future risks and provide greater security under U.S. immigration law. Understanding these points helps separate fact from speculation and ensures you make informed, practical decisions without unnecessary worry. At Legal Lens USA, our commitment is to honest, fact-based reporting. We aim to provide clear, accurate updates on immigration developments so you can understand how proposed changes might affect you without fear or exaggeration. If found this video helpful, consider subscribing and sharing it with others who need reliable information. We also welcome your comments and suggestions for future topics so we can cover the issues that matter most to our viewers. A quick legal disclaimer: this video is for informational purposes only and does not constitute legal advice. Always consult a qualified immigration attorney for guidance specific to your situation. Finally, remember this: by staying informed, consulting experts when needed, and planning carefully, you're taking the right steps to remain prepared, protected, and confident no matter how immigration laws evolve. Hola, atención un momento. Esto es importante y pocos lo están explicando bien.